Ready, start. The additional sessions Judge 3, Hardoi wide his judgment dated September 5, 1990 acquitted A3 as the prosecution was not able to establish any case against her full stop. However, on the basis of the prosecution evidence, the additional sessions Judge 3 held that the prosecutrix was about 17 years of age at the time of occurrence of crime and found A1 guilty under sections 363, 366, 368 and 376, IPC and sentenced him to undergo 7 years rigorous imprisonment under section 376 IPC and the different sentences for other offences which were ordered to run concurrently full stop. A1 challenged the judgment passed by the additional sessions Judge 3, Hardoi before the Allahabad High Court, Lucknow bench, Lucknow full stop. The High Court wide its judgment dated March 11, 2003 reversed the judgment of the trial court and acquitted A1 full stop. While acquitting A1, the High Court gave three reasons, namely, kidnapping took place on September 19, 1989, whereas the report of the occurrence was lodged after 10 days and there was no reasonable and plausible explanation as to why the report could not be lodged promptly and why it had been delayed for 10 days, second, according to the medical evidence, the prosecutrix was found to be 17 years of age and she could not even of 19 years of age at the time of occurrence and no internal or external injury was found on her body and she was habitual to sexual intercourse full stop. We deem it appropriate to reproduce the entire reasoning of the High Court as it is, which reads as follows. It has been submitted by the learned counsel for the appellant that according to the prosecution, alleged kidnapping took place on 19 September, 1989, whereas the report of the occurrence was lodged after 10 days full stop. There was no reasonable and plausible explanation forthcoming from the side of the prosecution as to why after alleged kidnapping of a minor girl a report could not be lodged promptly and why it has been delayed for 10 days full stop. This by itself shows that the report had been lodged after consultation and after due deliberation and the prosecution can be safely looked without full stop. I fully agree with the contention of the learned counsel for the appellant and furthermore, according to medical evidence on record, girl in question was found 17 years of age and she could be even 19 years of age at the time of alleged occurrence full stop. No internal or external injury was found on her body and she was used to sexual intercourse full stop. The charge of rape also stands not proved full stop. The learned court below was thus not justified in believing the prosecution theory and convicting the appellant full stop. We are indeed surprised by the casual approach with which the High Court has dealt with the matter full stop. The judgment of the High Court is not only cryptic and perfunctory, but it has also not taken into consideration the crucial evidence on record full stop. On flimsy grounds, the accused convicted of a serious crime of kidnapping and rape has been acquitted full stop. There is no application of mind to the evidence of the prosecutrix at all full stop, having not been benefited by the proper consideration of the evidence by the High Court, we have looked into the entire evidence on record carefully full stop. The prosecutrix is an illiterate and rustic young woman full stop. She does not seem to have had formal education and therefore, there is no school certificate available on record full stop. In the FIR, the age of the prosecutrix has been stated to be 13 years full stop. In her statement recorded under section 164, CRPC, the prosecutrix stated that her age was 13 years full stop. PW1, who is elder brother of the prosecutrix, in his Deposition also stated that the age of the prosecutrix was 13 years at the relevant time full stop. However, the doctor PW5 on the basis of her x-rays as well as physical examination opined that the prosecutrix was 17 years of age full stop. The trial court, on consideration of the entire evidence, recorded a categorical finding that the prosecutrix was about 17 years of age at the time of occurrence, full stop. This is what the trial court said. According to the complainant, Rampal, PW2 was aged 13 years at the time of the occurrence, but during the cross-examination, the complainant has stated in para 7 of her cross-examination that he was aged about 24 years and PW2 was younger to him by 8 to 9 years full stop. Thus, the age of the prosecutrix, according to the statement of the complainant, comes to 16 years full stop. Stop.